Hello viewers. In the next half an hour, I am going to talk about IBC ecosystem and the way forward. Friends, as you know, the code has been really a far-changing economic reforms in the last 5 years. It was a imperative, in fact, I would say, it was an imperative need for our country to try and catch up with the rest of the world, be in terms of ease of doing business, recovery of loans, maximizing the assets of the ailing firms, and of course balancing the stake of all stakeholders. And if you see the long title of the code, it is in fact loaded with so many objectives. And if I may say so, the first time in the history of the economic legislation in India, the Parliament conceptualized a complete code for the economic activities. And that is why this law is not called an act as normally we call our legislations. This is called as code because it has codified several aspects of the economic activities in the regime of the insolvency and the bankruptcy, be it in terms of the kind of creditors, the kind of entrepreneurship and businesses, the kind of structures they are in, the processes, and also it has codified not only the substantive law, it has also codified the procedural requirements, providing for the appellate authorities, the adjudicating authorities, administrators, regulators, and various other entities. So that is how the Parliament has enacted this as a code. In the ecosystem, if you see, the code is an economic legislation. So like any other economic legislation, it cannot be a perfect law. It has been tested and it is testing the economic needs, the complications and intricacies arising out of the businesses, the complications and intricacies arising out of the insolvency processes. And to that extent, the Parliament, while enacting, has also given the mandate to the government to implement the code in a phased manner. It has also enabled the Parliament and the legislation to address the needs whenever the demands arise from the market or the complexities arise out of the resolution processes. And with this objective, if I may just mention that the journey so far had been that in 2016, the code was implemented for the corporate insolvency resolution process, that is the resolution processes for the companies and those structures which are with the limited liabilities like LLPs. And in 2017, then the government notified two sections, sections 234 and 235, which are to some extent dealing with the issues arising out of the cross-border, which I will be discussing later. And in 2019, then the government issued the notification for the resolution processes for the resolution of the financial service providers, which are not basically covered under the detailed procedure of the code. And in 2021, depending on the market demands, again, the code was amended to provide for the framework for the pre-packaged insolvency resolution, which basically is the private negotiations between the debtors and the creditors prior to the initiation of the process. And how the amendments happened, just a snapshot. The first amendment was brought in 2017 when this section 29A was introduced. It is much talked about the section under the law. This section disqualifies the persons who had been really responsible for distress of the firm. And they are basically the willful defaulters, the persons who are holding the NPA accounts, who are undischarged insolvents, or who have been disqualified by any of the regulators or the government or the courts. So these persons cannot be given the control of the company or the corporate again through the resolution process route. This section disqualifies these people. Second amendment came when the home buyers were included in the definition of the financial creditors, and the withdrawal was permitted by providing a specific section 12A. The third amendment came when the timeline for resolution was given 330 days, including the time taken in the legal processes. And then the plan has been made binding on all the stakeholders, including the government and other regulatory bodies who have any dues to the corporate debtor. Once the plan is approved, if they have not filed their claim gets extinguished and plan is implemented, and the corporate debtor is given to the resolution applicant as a clean slate. The next amendment came, that is fourth amendment, when section 32A was introduced, and this section gives the immunity to the corporate debtor from any liability which had been incurred by the previous management. Of course, the previous management has not been given immunity, but the corporate debtor has been allowed to go in the hands of the resolution applicant on the clean slate without any responsibility and liability. The fifth amendment came due to the COVID pandemic when the code was suspended, and the last amendment came about the, as I mentioned, about the prepackaged insolvency regime. So going forward, this was the basic ecosystem under the code and how we have proceeded so far. The next way forward, of course, the three aspects I am going to list today is the individual insolvency, cross-border insolvency, and the group insolvency. Individual insolvency partly implemented, cross-border and group insolvency are yet to be. Individual insolvency, again I would say, considering the market demands and the intricacies arising out of the resolution processes, particularly with regard to the liabilities of the personal guarantors of the corporate debtors. When I say personal guarantors here, I mean the persons, the individuals who have given the guarantee to the corporate debtor. Friends, this code is very unique. As I said, it is not only dealing with the corporate debtor, it is also dealing with the contingent liabilities, the contingent debtors, the contingent creditors. So that way, it is also was thought fit to bring the personal guarantors in the realm of the corporate resolution insolvency process. And with this idea, the government issued the notification to include, government has been given power to notify any class of persons or the chapters which would be applicable at appropriate time. And this was tested before the Supreme Court in a case, that is Lalit Kumar Jain's case, in which the challenge was that government has implemented part 3 of the code, which is applicable to the individuals, bringing the individual guarantors under the realm of part 2, which applies to the corporate debtors. So very interesting judgment. Of course, I am not going to go into the greater detail of judgments, but this was tested by Supreme Court, that how this notification, could this be a conditional legislation or it is a proper delegation. Those issues were addressed, but at the same time, Supreme Court felt that the administrative instrument by which the government has been implementing the particular chapters or extending the code to a particular class of people is a valid mode of doing, and the Parliament has allowed the staggered implementation of the code as and when the market demands or the need is felt by the executive wing of the government, that is the central government. So that is how the Supreme Court also gave a lot of findings about the economic legislations, how they should be interpreted, how the parliamentary power should be conceded in the favor of the economic legislations to give way to the economic developments. And they also said that economic laws cannot be conceptualized and contemplated at a particular time. So that is how the staggered implementation of the code is permissible and also desirable. So how it happens that if I'll just go to the individual insolvency before I go to the personal guarantors, the law today about Presidency Towns Insolvency Act and Provincial Township Insolvency Act, which applies to the bankruptcy of the individuals, is yet not repealed. What does it mean? It means if you are willing to start a process against a insolvent individual who is not a guarantor, who is not a debtor, then the forum is different. You can proceed, but of course you cannot start the process under the code. That process would be under these enactments before a different tribunal. But if that individual has given a guarantee, then he has to come in the ambit of the code, and the jurisdiction is given to the National Company Law Tribunal, which is the adjudicating authority dealing with the corporate insolvency resolution process of the corporate debtor. And then the code was amended to say that if the proceedings are pending before the initiation of the resolution process of the corporate debtor before the debt recovery tribunal, who is the authority for dealing with the insolvency of the individuals, those cases would be transferred to the National Company Law Tribunal, and where the corporate insolvency resolution process is continuing about the corporate debtor, there only the resolution process of the personal guarantor would also be started. The three processes, as I said, under the code about the individuals, applicable to individuals, are individual insolvency resolution process, the bankruptcy process, and the first start process. Insolvency about the personal guarantors has come into force. The phase 2 about the insolvency of the partnership firms and the partners is yet not to be notified, and the insolvency and bankruptcy of other individual is also yet to be notified. The first start process is basically a debt waiver process. And before that, I can just recap. For individuals, these are the two different tribunals. If he is a personal guarantor to the corporate debtor and the resolution process, be it CIRP or liquidation, is pending, then the authority is the NCLT and the NCLAT. If CIRP or liquidation is not pending, then it is DRT, Debt Recovery Tribunal, or the Appellate Tribunal. For individuals, firms, and other individuals, it is Debt Recovery Tribunal. For individuals, firms, and other individuals, the code is yet not implemented. Legal challenge I just mentioned, and the upcoming areas would be the partnership firms and other individuals. First start process is a process which is basically a debt recovery waiver process. It is basically to address the weaker section of the society. If you see the 6 boxes, the process is like that. Before that, if I may mention, the person who can get the benefit are those whose gross annual income is rupees 60,000, their value of their asset is equal to or less than 20,000 rupees, and they don't have any dwelling unit, they don't have a residential house. So they get the waiver of rupees 35,000 rupees. This process yet not implemented. The application is filed by the debtor, then a RP is appointed, due diligence is done by the RP, then he takes the admission application, is filed before the authority, and objection is invited, and the debtor is discharged. This process is yet not implemented. The next important reform which government is today discussing and contemplating is the cross-border insolvency. Friends, as we know that post-liberalization, particularly in the last 3 decades, the interconnectedness of the economies has been increasing. The businesses are now losing boundaries. The entrepreneurship is crossing the boundaries. The people are also operating outside. The investments are happening in the domestic countries from foreign individuals, foreign nationals, foreign companies. If I may mention from the World Investment Report, last year, the developing countries' share to the FDI and ODI had been twice than in the developed countries. And out of that, India stood fifth to receive the FDI and ODI. So, the market is further deepening about the foreign investments. The assets and the corporate and the creditors may be abroad. The Indian corporate may have establishment outside. So, how to deal with the insolvency of such cases? In the code, there is a provision, but in the international forum, international law, if you see, those forums are not that effective. I am going to talk briefly about that. And they aim to resolve, if I may say, the business have interest stretching beyond boundaries in insolvency of corporate debtors that have assets or creditors in more than one country. These are the challenges. The creditors situated in different countries and their claims are governed by different laws. And more difficult is this under the domestic regime. The enforcement of the judgments of the domestic courts is very, very difficult. Another, these are the two sections I said, 234 under the code, which allows the government to sign agreements and treaties with the countries on the reciprocity basis. Other section is the letter of request from the adjudicating authorities. Both these sections were notified in 2017, but yet not implemented. There is no such bilateral agreement, no such letter of request. Because of the intricacies involved, because of the effectiveness involved, this process has not evolved so far. Using inherent powers, the domestic tribunals have decided few cases, like Jet Airways case was settled by the adjudicating authority by exercising its inherent power under Rule 11 of the NCLT rules, where the assets had the reach beyond the Indian domestic jurisdiction, and the resolution could be done using the inherent powers. Another legal regime is Section 13 and 14 of the CPC, which has its own inherent problem. Enforcement of the judgments in the domestic courts happen as a question of fact, further proof, further establishments. These things are the required. So these judgments, these courts judgments are also not very efficacious, very, very effective to deal with the large conglomerates of the international existence of the creditors and the corporate debtors. The existing options I mentioned, these are three options. The other is the inherent power, but these are not very effective. Why? Because these are the matters relating to the private international law. Friends, as you know, these regimes, what are there in the code or under the CPC, they could be implemented through the rules of the private international law. That is, the rule of international committee or treaty. Here, various aspects of the judgments remain untouched, like recognizing the foreign proceedings as if are deemed to be implemented like a domestic judgment. Similarly, they also have limitation about the lack of clarity of jurisdiction. They also have the lack of clarity of the claims of the creditors. They also have the necessary tools to address the cross-border issues that impedes protection of assets. The time taken and the is also connected with the value of the assets. The more the time taken, the value deterioration happens very fast. So these processes involve a lot many time and efforts. So as you know, as Webster said, that under the modern economic laws, now the modified universalism, he labeled this concept as modified universalism, where the individual countries adopt a model law. And on the basis of universality, these model laws are given respect in each of the jurisdictions where they have been adopted. So model law here is ancestral 2017 model law on the insolvency judgments, that is normally in the insolvency regime called MLIJ. So they provided a model law, and in India, many of the committees recommended for the adoption of that model laws because the existing regime was not found to be effective and efficacious. And then model laws has been piloted and recommended by various committees. In India, many of the resolution processes involve the cross-border issues like Shilpi Cables case, MTech Auto case, Jet Airways case, VOVL Limited, SEL Manufacturing Limited, and many more. So prior to this conceptualization, many committees recommended, BLRC recommended, JPC recommended, Insolvency Law Committee in 2018 recommended. I am not reading those recommendations, but you can just make a reference and go through them. Then report of the ILC on the cross-border framework in October 2018 finally recommended adoption of the ancestral model law and also suggested some regulatory framework which is being examined at the appropriate level. The Standing Committee on Finance in 2018 again recommended International Monetary Fund, World Fund, group of members of FSDC, they all recommended for the adoption. The various features of this model legal framework is that, as I mentioned, the direct access across the jurisdiction. Then recognition of the proceedings, the recognition of foreign insolvency proceedings by domestic courts as main and non-main proceedings, and relief for main proceedings and discretionary relief for non-main proceedings. Then cooperation. The cooperation is about direct cooperation of the foreign courts, domestic courts, foreign insolvency representatives, and domestic insolvency professionals. So under this regime, there would be a direct connect, of course through the government channels, where there would be direct cooperation arrangement. Then a direct coordination arrangement of the court and concurrent insolvency proceedings. Suppose insolvency proceedings are happening in India and also abroad, the framework would also provide for the coordination mechanism. Many of the countries, around 50 out of the 53 jurisdictions, have already adopted. Australia, Singapore, UAE, UK, and USA are amongst them. And rationale, as I mentioned, it is comprehensive, flexible. It adopts the international judicial cooperation, guides direct cooperation and coordination, increased investment trade. The economic imperatives are increased investment in, just if I may mention, if any FDI happens, if any investors come to any country, he always keeps in mind that how his returns would be guaranteed. And one of the means he looks for whether the domestic jurisdiction has a robust insolvency law to give him protection. So that way, it will give a comfort to them. It also increase the labor flows. It will increase the ease of doing business. It will increase competitiveness amongst the private channels as well as the value chains. That is how it will increase the ease of doing business. And Australia and Singapore have given some witnesses, have been witnessing these things. The positive messaging at the international stage, progressive forward-looking market reform, this will be really a very forward-looking reform to deal with the cross-border issues through the IBC regime, and it will yield in better results. The other item is the group insolvency. Group insolvency again is not very clearly or very specifically provided, but there had been market developments where you know that in the domestic stage itself, there is a large conglomerates of the corporates. They work through subsidiaries, they work through establishments, they work through other branch offices. So the code has so this happens in the Companies Act through voluntary liquidation, through consolidation, through merger acquisitions. But under the code also, going forward, there could be some thought on the group insolvency. Thank you so much.